Good morning, Ms. Newman. Good morning, Mr. Wood.
Good morning, Your Honor. May it please the Court, my name is Chauncey Wood, and I represent the appellant, Lord Hampton. The prosecutor's jury selection tactics in this case were fundamentally unfair. After jury selection had been completed, he obtained query reports on a select group of 4 of the younger jurors in an effort to disqualify them.
Were any of them disqualified as a result of the prosecutors getting these reports?
One of them was disqualified. The judge stated clearly that she was disqualifying him. This is juror 10. She was disqualified.
Not as a result of the reports.
She said that's true, Your Honor. However, she also said...
So my question was, if any of these 4 people that the DA looked at their records was dismissed because of their records.
Your Honor,
what's the answer?
The answer is, your question, let me back up. Your question implies that there is a requirement of a showing of prejudice.
I'm just asking.
Sure. As a factual matter, she said 2 things, and I need to make a 2-part answer. The direct answer is no one was disqualified explicitly because of the findings of the prosecutor.
Or implicitly.
Well, yes, but the second part of the answer is that the judge also explicitly stated, if I hadn't had this separate basis, his looking at a newspaper article and discussing it with the other jurors in violation of her order, I would have dismissed him because of his criminal record.
That's interesting, but totally irrelevant.
Well, Your Honor, I don't think it's relevant, but again, I need to back up. Both of you are implying clearly that you think there's a requirement of prejudice here. I reject that premise.
No, we're not even saying prejudice. We're saying if it isn't a ruling that applies to this case, there's nothing before us on the issue.
Absolutely. I respectfully disagree.
But nothing happened as a result of the investigation of the 4 jurors' backgrounds.
Your Honor, the challenge here is to the prosecutor's tactic. With all due respect, I submit that it doesn't matter. It's not a requirement in this context to show that something happened, as you put it. I submit that the problem here is a constitutional problem. It's indeed a structural error going to the defendant's 14th Amendment right to due process in terms of fundamental fairness, implicating a 6th Amendment right to an impartial jury, if I could be permitted to explain. The point here is that the prosecutor, using his unilateral power to check Corey records, handpicks. He's essentially continuing the jury selection process. He handpicks 4 of his least favorite jurors. He describes them as 4 of the younger jurors, and he does Corey checks on them. The problem here is that he prevents the defense counsel from having the same access to the Corey records of the remaining 14 jurors. The problem, and moving beyond that, the issue is you're asking what harm can come from this. In addition to the harm that the prosecutor can get rid of jurors that he doesn't like, and here serendipitously there was a separate reason to get rid of the 1 juror that actually was gotten rid of, so he didn't have to rely on that basis. But there's a separate problem. The separate problem is that the prosecutor is now in a fundamentally advantaged position over the defense counsel. Defense counsel cannot look at those other 14 jurors and say, do they have any criminal records?
Okay, would you be content if we said that any time the prosecution gets the criminal records of the jurors at whatever point in the trial, it has to immediately be shared with the defense attorney?
No, that's not enough. I submit that the proper solution here, with all due respect, Your Honor, is twofold. The proper solution is, first, it's a 2-part rule that should be adopted, I submit, to satisfy due process and the 6th Amendment right to an impartial jury. The prosecutor must, if he's going to check or she is going to check criminal records of jurors, he or she must check the criminal records of all jurors selected to sit, alternates and deliberating jurors. Second, the prosecutor must do so before he or she has announced that he or she is content with the jury selection process.
Okay, what if the judge will not permit time for the prosecutor to do that? Says immediately after the jurors are all selected, we're going to swear the jury right now.
Well, I don't believe that as a practical matter there would be any significant difficulty. I think that the prosecutor, it's clear from the record in this case, I don't have a cite off the top of my head, but that the jurors, the jury commissioner gives the list of jurors to the prosecutor and defense counsel, or at least it's available, a week before the trial. The prosecutor can use that list to run the criminal records of the jurors that are going to be selected.
The entire venire.
Excuse me?
Then the prosecutor would have to run the list of the
They could do
entire
that.
venire.
Well, they could do that. I submit that to the extent that there is a time delay, they could do that, or I think that it's not unreasonable to take a brief recess to run criminal records if we're talking about...
Fine. Some judges don't like to do that.
Well, with all due respect, I think if it's a question of balancing the 14th and 6th Amendment rights, constitutional rights of a criminal defendant versus a judge's desire to get something done 10 or 15 minutes or 30 minutes or 60 minutes quicker, I submit that clearly we have to answer that the defendant's rights trump there. We're not talking about any more than an hour. I apologize, Your Honor.
It isn't the defendant's rights, though. It's usually the government who says we'd like a recess to check the records, and some judges want to immediately swear the jury and get on with it.
Well, then, I'm sorry to cut. I didn't mean to cut you off, but I'm sorry. I guess that makes my argument stronger, that if the government is, in fact, also in favor of this delay to check criminal records, then I would argue that that makes it even a better reason for the rule.
So then at what point does the defendant get access to this information? You said first the district attorney should check all jurors' records, and second, they should do that before they are content. Now, there's got to be another step, too, doesn't there? That is that after the DA looks at the records, they give them to the defense counsel.
Yeah, Your Honor.
You're saying in this case, one of your complaints is that the defendant did not have access to the records of the other jurors. So
yes,
you want to build that into this, too.
I think I agree with you. I'm saying that the defense should have equal access to everything.
At what point in time?
Well, I guess it depends. If the prosecutor is, in fact, going to, whenever the prosecutor is looking at things, the defense counsel should be given access to them. I think that probably, in fairness, whoever, as soon as the prosecutor runs the criminal record of a juror, the prosecutor should and receives it, the prosecutor should immediately turn it over to defense counsel. This New Hampshire case that I cited in my brief, Goodale. The situation there was, I think, sort of implicates maybe what you're getting at, this tactical issue where the prosecutor has these criminal records of jurors, the next one coming up, and so can determine, should I exercise a peremptory? I've got this criminal record. I want to avoid that situation as well, so that there's no tactical advantage to the Commonwealth, if that's what you're getting at. I think that clearly the proper rule is for the prosecutor, the defense counsel, to have access at the same time the prosecutor has access to the criminal records.
I take it, Mr. Wood, that to really give full meaning to that, it would be that the prosecutor is informing the defense attorney, I am going to run query checks, correct?
Well, I guess that, sure, that, I guess I'm not quite sensitive to the point you're making.
Well, the point I'm making is that it's possible, I assume, that if the defendant knows that a query check is being run, I mean, it may come back negative, it may be nothing, that the defendant and whatever the defense counsel is doing with respect to the selection of the jury at that particular moment, I mean, what we're trying to avoid is saying you've got to run the check before A, B, C, D, because as Justice Cowan pointed out, when you say you must check the criminal records of all jurors, you're not talking about it sometimes takes 200.
Yeah.
I mean, you understand the problem. Right. So we're now getting into what we've got, you know, of the 200, 100 others are out anyway.
Right.
And so you're not wasting up resource times. And I'm trying to figure out if you really are trying to equalize, then one should know this is the process that's being done.
This is becoming obvious. This is obviously an evolving area. It's obvious that I think the court's aware of this. That prosecutors are. This is a new thing that prosecutors are doing.
I mean, one way to look at this is to say prosecutors can't do that. We don't say that because we had a difficulty with people not revealing their criminal histories. You know, a purist view would be too bad. It's a jury of your peers, and a jury of your peers, some of whom lie, some of whom don't lie. That's a jury of your. We have chosen not to go that way, and you're saying, given that we've chosen not to go that way, how do you make it equal?
That's what I'm saying.
Genuinely equal.
Just to be clear, I'm not repudiating or trying to ask this court to overturn Cousin. I think that it's appropriate to check the criminal backgrounds of potential jurors. I think from an administrative point of view, and I apologize, I haven't really thought this through as thoroughly as Your Honors are obviously thinking it through, but I think perhaps from an administrative point of view, the easiest thing to do to minimize burden on the court and the waste of time would be to modify the Cousin rule to say that the prosecutor is entitled to check criminal records of jurors, but not until whatever number they've agreed on, 12, 14, 16, 18, have been selected. And at that point, if the prosecutor wants to check the records, he or she can check the records. As soon as he or she receives the records, hand them to defense counsel. The parties will have a brief opportunity to review this information, see if there's anything inconsistent with the jury questionnaires, and then go from that point forward. That eliminates this danger. I think that would probably be better than having a stack of queries for 200 jurors. I think that would probably be administratively better.
I take it we would also have to instruct trial judges that they cannot just do, as Justice Cowan said, is, I don't want to delay. If the prosecutor wants to check Corey records, there will be necessarily a delay. Delays happen. It might be because somebody is reported to have read a newspaper article. There is a delay. The judge cannot say, I don't want any delays, let's just keep going. You can't do that.
Right.
Now, what happens in the struck method, if the struck method is used? The decision whether to accept a juror has to be made right then and there if there's an individual voir dire, not fill the box first.
First of all, the vast majority of my practice is appellate, so I'm not an expert on the distinctions. I understand the distinctions you're making. I've read them. If what you're saying is the struck method, you put the juror in seat number 1, anybody got a problem with him? If nobody has a problem with him, that's it. He's on. Yep. There's no more opportunity to check him. Yeah. I think that administratively, in that system, I think that's easier perhaps. You could probably, at that point in the struck method, authorize the prosecutor to run the Corey record if they want to. Again, as soon as they get it, give it to the defense counsel.
That doesn't work out, Mr. Wood, because the prosecutor can't leave the bench and go give the paper or tell somebody if the prosecutor doesn't have an assistant in the courtroom, which happens in many counties. Maybe not Suffolk, but in other counties.
Well,
what do they do in I'm sorry.
Certainly, you know, if you don't have a homicide case and you may have a single prosecutor who's got a jury and the district attorney's office and defense counsel, CPCS, may decide one attorney is sufficient. So,
right.
I mean, juries, of course, are not just in homicides. So we've got whatever rule we make might be for a relatively low-level misdemeanor as well.
I mean, I think that, again, in the current situation, it's inappropriate to do what the prosecutor did here. I mean, here, the prosecutor didn't do it right away. The prosecutor waited until there was a break in the trial at the end of the day to do it. So
that's even worse.
We're not. You know, we're talking about a general rule now. We're not talking about this case. I think.
Well, but I mean, what I'm saying is the fact that there was only the problem wasn't in this case wasn't that there was more than a prosecutor. But the problem wasn't the lack of a number of prosecutors. So I think that if they don't want it, that's a prosecutorial decision. If you want to devote additional resources to be able to check criminal records in a timely manner, then get somebody else, an assistant. They have the whole police force on their side. I mean, if you're talking about resources, the Commonwealth beats the defense every time.
So what you're suggesting here, and what is apparent, is it's more troubling, or it is troubling, when during the trial the prosecutor decides he wants to check, or she wants to check, some of the records of some of the jurors.
Yes, absolutely.
The trial's not going well. Some of the jurors are reacting kind of negatively to the Commonwealth's evidence.
Yes.
That is the most troubling part.
And that is precisely what happened in this case. The prosecutor explicitly stated that after the opening statements were made, he was watching the faces of several of the jurors, and he decided, because of the reactions on their faces, to check their criminal records, and only their criminal records, 4 of the younger jurors. So he stated explicitly, I'm not hypothesizing here, that he wanted to make sure that these jurors had not lied. But that's the way he put it. But of course, what he's really saying, at the same time at least, is
I don't like
them.
Down.
Right. And
so
yes.
could we essentially, I don't know whether we could do this or not, say that once the trial has begun, checks of juror records can only be undertaken with approval of the court?
Well, I would
With an exception that should something unusual come to the attention, because don't forget the cousin case was something that came to the attention, and which happens not really in criminal cases. Some police witness comes in and sees a juror and says, "I recognize him. I arrested him, 3 years ago," and that. So perhaps
that would be a very good reason to bring to the court's attention why jury checks need to be done.
That was in fact the cousin case.
I'm talking about prospectively. We're talking about an evolving area, and we see that there may be abuses, and we may need some additional sets of rules. We didn't do them in cousins, but now's the time to consider them.
I think I agree with both of you. I think the general idea is there should be a general rule, and of course, this court always there are always exceptions. That's why we have lawyers. We develop, if there's an exception, with good cause, the parties can bring that to the court's attention, and I don't have a problem with that, no.
Mr. Wood, you started by saying it's a structural error.
Yes.
I don't have to tell you structural errors are pretty bad errors, right? So what's your best case?
Well, first of all, I didn't brief this issue. So if you're looking for it in my brief, also my reply brief I filed yesterday because of the short time frame we had here. But you're not going to find it in my reply brief either, although I do ask you to. But it occurred to me last night that what this is doing is impacting, because I was thinking about the prejudice question that Justice Ireland and Justice Cowan started with today. And it occurred to me that this is the problem here gets to the jury, the defendant's ability to have an impartial jury. And the right to an impartial jury is, in fact, a fundamental, and the violation.
So why didn't he have an impartial jury here? If the prosecutor had not gotten these probation records, you wouldn't be complaining about this jury.
I submit that it's the process, that it's the right to a process that results in an impartial jury.
But what evidence do you have that this jury was not impartial?
We don't have evidence. That's precisely why I submit that this situation cries out for a structural error analysis.
But in this case, the jury was the jury that was picked, and except for this one juror violating the judge's order about the media, it was the jury that was picked. Nothing happened. I mean, we can make a rule going forward, like you suggest, or something different, or whatever we do. But I fail to see anything that happened in this case.
Let me suggest this, Mr. Wood, before you answer. Because of our 33E review, and because this is a murder one case, I would like to be briefed on structural error, which would give the Commonwealth the same point. Because I understand why we may have a prescriptive rule, but from your point of view, that doesn't help your client, unless, I think, if I understand you, unless we conclude it's structural error. You don't have to agree with that assessment of mine. You may say, I can show prejudice in some other way, even if it's not structural error. That I understand.
Okay.
But I do think, and there is something, I happen to be interested in structural errors, and so it's not a frivolous claim. And because of 33E, just brief it.
Okay, I will. The answer to your questions is, again, and I'm repeating myself to some extent, the problem here is, it's a difficult problem to articulate, but the problem is what we don't know. The prosecutor learned of a basis to exclude one juror. There's no dispute. The trial judge stated explicitly, if I hadn't had this other basis to exclude Juror 10, I would have excluded him because of this Corey lie. The problem is that the defense counsel doesn't know what he doesn't know.
Did the defense counsel ever ask to
yes.
have and what happened?
Defense counsel asked explicitly. I've got it here. As soon as he learned about this, defense counsel, and I'll give you the exact site, chapter and verse, on Volume 7, page 168. This is a quote from defense counsel. I would like to know, were criminal history checks done on any of the other jurors? And if so, what were the results of that?
Oh, I remember now. She said she wasn't going to.
And the judge said, and I honestly, I'm not going to add, and this is at 172 of Volume 7, I'm not going to ask and engage in investigation in discovery as to what else the Commonwealth did or didn't do.
No, but my question is, did the defense ask for the records of the 4 jurors whom the Commonwealth indicated it had checked?
Yes, the Commonwealth provided those
and
records.
They were given to the defense?
Yes.
Okay,
yes.
So you at least had what the Commonwealth said it had gotten.
Yes, I'm sorry. I thought you were getting at my argument here is the defense doesn't know what he doesn't know, the 14 other jurors. And so the question is, how do we know he didn't have what evidence do you have that he didn't have an impartial juror? The problem was...
Wait, do we know that the Commonwealth looked at the other jurors' records?
No, the
No,
contrary.
but
We
your-
know that the Commonwealth didn't look at the
Yeah,
other
but your
jurors.
argument is they're picking those 4
Yes,
because they didn't like the looks of those 4.
yes.
And if we had looked at the other 14, we might find somebody with real bias one way or the other.
Yes.
So if you're looking at 4, then I'm entitled to look at the.
Right.
By
And
the
defense
way,
counsel tried to. Defense counsel
no, I
explicitly
understand.
said,
No, I
I
understand
want
your
those.
argument.
Right.
I understand your
And yes, so that's the issue.
But if I understand you, you're also saying the defense should have access to exactly the same information that the district attorney has.
Yes.
So if the district attorney hasn't looked at the other jurors' records, the defense is in just the same position as the Commonwealth is.
That's yes. In this case, you're right. You're right. I'm sorry, I know my time's over. But to answer your question, the defense in this case did in fact have the same information that the prosecutor had. Yes, that's true. But that's why. But that doesn't address the unfairness. I submit that the second part of the first part of the test
Mr.
is.
Wood, forgive me for interrupting you, but we'll be saying the following. We've got a jury. We're going to ask 4 of them to fill out questionnaires. And then, depending on what they say in those questionnaires, we're going to either seat them or not seat them. There are another 14 over here. We're not going to ask them to fill out questionnaires.
I mean, of course, yes. I understand your point.
That's
yes.
your argument.
Yeah,
that
in
if for
essence.
some reason, because of facial expressions or age or something, we ask these 4 to
Two levels of investigation.
Correct.
That's
so
what
if
I'm
you're going
saying.
to ask these 4 to fill out questionnaires, which are doing a quality check, is essentially asking them to answer the question.
And
Then
the
you've
crucial
got to
thing-
do it for the whole.
And the prosecutor chooses those two groups.
No,
That's
I-
the
I-
worst part of it. The
I
prosecutor
understand.
chooses the two groups.
Was this made the subject of a motion for new trial?
No, it was not.
So there's information out there that is necessary for the resolution of this particular question?
There is not. And in fact, and that's a good question, defense counsel, after being shut down by the trial judge for trying to get this information, said, at the very least, Your Honor, I would ask that whatever the Commonwealth has done, that they be preserved in a way for appellate review, because maybe I didn't explain it. And he goes on. And then the prosecutor, the short answer, the judge says, no. All right, well, I've made a ruling. I'm not asking and ordering the Commonwealth to do anything else. Bring in the jurors. He tried desperately to preserve this for appellate review. I thought specifically about a motion for new trial. There was no point because of that. The trial judge made it impossible to recreate the appellate record, the record here. So there was no point from my tactical point of view, in having a motion for a new trial. The record is what it is, and we can't make it any better. Defense counsel tried to preserve the record for precisely this point, but couldn't, and the trial judge prevented it.
Thank you, Mr. Wood.
Thank you.
Good morning, Ms. Saxey.
Good morning, Your Honor. May it please the Court, Hella Saxe on behalf of the Commonwealth. This Court should affirm the defendant's 2 convictions of murder in the first degree and should decline to exercise its authority under 278, Section 33E.
You see no problem with what happened here?
Not at all, Your Honor.
How do you answer my question about the prosecutor halfway through the trial says, I don't like the facial expressions or whatever it is, which I don't say unfortunately, in a way the prosecutor was being very straightforward. I'd like to ask further questions about those 4.
Under the Cousin case and under...
Didn't address that issue.
I'm sorry?
Cousins didn't address that issue.
But the Commonwealth has the authority and the discretion to obtain criminal records of...
No question about that, but does the Commonwealth have the authority, A, to withhold? You would say no.
There was nothing withheld, and Cousin makes it explicit that the prosecution has to disclose immediately, and that was done here.
If the prosecutor said, I want to examine these 4 jurors.
The prosecutor is perfectly authorized to do so.
In the middle of the trial, if the prosecutor said, I'd like to ask again some questions because I'm worried, I mean, doing a Corey search is a functional equivalent of asking a question, but I don't want to ask the questions of the other 10 or 12 or 14, how many other jurors there were here.
At that point in time, when the prosecutor had disclosed that information to the court and defense counsel, the defense attorney would have had the opportunity to explicitly ask the court to obtain the records of all the other jurors.
And the defense counsel did here?
No, he did not. He
I
merely...
thought that's what Mr. Wood just said. I want those records.
No, my reading of that Chapter 7, page 168 in the transcript is he speculated about, well, I wonder if the Commonwealth has obtained any other records. And what they say, he never asked the court to... And the court has the possibility and the resources to ask the probation department to obtain all these records.
Let's assume that we agree with Mr. Wood that the record establishes that defense counsel wanted to look at the Corley records of all of the jurors, the alternates and the seated jurors, and the judge declined that request. Is that a problem?
It isn't, because the prosecutor's actions here were authorized and discretionary, and the court...
No. It's not that. I'm not suggesting that the prosecutor did anything wrong. I'm looking at the judge's ruling. Let's assume that because we have to, if we decide to elaborate on Cousins, we have to. So if the defense attorney asks to see the Corley records of the remaining jurors, and the judge says no, how can that be correct?
Well, at this point in time, there's no indication that the defendant did not have a fair and impartial jury.
No, but you're not answering my question, Ms. Saxey. Forget about this case.
I think going forward, the best solution for homicide cases.
We don't distinguish due process rights based on the seriousness of the case.
No, I think, but just for practical reasons, would be to.
No, we can't do it on that basis.
Order the lower courts to, before the jury is sworn, after it is seated, before it is sworn, order the probation department to obtain the records of all seated jurors.
Why would you limit that to homicide cases? What about...
I think just for practical matters.
But on what conceivable basis? I mean, somebody is charged with a very serious crime. You've got victims of other very serious crimes. Aggravated rape.
No, let me ask you a question. Do you have a problem going forward with the solutions suggested by the defendant or by the court with the defendant's input that first of all, any probation records are to be obtained before the jury is sworn, number one, even if we have to limit the discretion of trial judges to deny continuances for that reason. And number two, that as soon as the Commonwealth obtains said records, they would have to be shared with the defendant. Do you have any problem with that?
I do not have a problem that these records have to be shared immediately. I think it would be a better solution if this...
excuse me, and with the caveat that if something comes to the attention of any party during the trial that requires a further Corey check in unusual circumstances, or however we want to couch it, that is authorized as well. The judge has the discretion to authorize a criminal record check at that time.
I would say, however, that it would be a better solution if this court did not require the Commonwealth to obtain these records if needed, but if the court itself...
No. This is if the prosecutor wants the records or if defense counsel wants the records. You can't give the prosecutor a right. I mean...
No, but if the defense counsel wants the records, the court can't order the Commonwealth to obtain them.
But the court can order the Commissioner of Probation to obtain. Is that your problem?
And that would be the best solution. Yeah, okay. It would be made available to the court and all parties. It would be fair. We would not be having this discussion anymore.
So you would not have, going forward, that wouldn't be a problem as far as you're concerned?
No.
Okay.
No, but just so that I understand you, Ms. Saxey, you said in homicide cases for the entire venire?
No, Your Honor, and I'm sorry if I misspoke. I don't think it should be limited to homicide cases. I was just thinking that because of the significant resources it requires, it might be a first step.
So if the prosecutor wants the Corley records, If the prosecutor wants the Corley records, neither party may want the Corley records for whatever reason. They look at the venire, they look at the questions, they figure that they've got the jury that they want. So neither party wants them. And so we just proceed. And then, as Justice Cowan says, in any case, if a police officer comes in or a witness or anybody else and says, I know that person, I served in jail with him, well, that's one thing. But leaving that aside, sometimes prosecutors don't want that. If the prosecutor wants them, the prosecutor can get them, and then we go under the thing that has to be done before the jury is sworn. We have to tell trial judges to permit the prosecutor to get that. As soon as they get that, they have to hand it over to the defense attorney, and presumably to deal with Mr. Wood's problem, you have to get it for all jurors, the 14 that is, or however many are sitting in the jury box. If the defense counsel wants them, then the court has to order the Commission of Probation to get them.
I think the rule should be that the court should obtain them through the Commissioner of Probation.
But the court doesn't know when the parties are going to want them.
I think just in general, before...
But we have thousands of jury criminal trials, and as a matter of due process, you can't give more rights to certain crimes than to others.
No, and I'm sorry if that my mention of the homicide cases creates a problem here. No, ideally it should be done in every case.
But why, if neither party wants them? Why? We have a system of jury selection that in the vast majority of cases has worked just fine. Namely, people answer questionnaires. I think they now swear them. Didn't we change that form? I think you now swear that the information is correct. And, that's the end of the discussion. So we're not going to use increasingly declining resources to run quality checks on thousands and thousands of cases every year.
Well, I think it would be a very useful thing. And here...
It might be useful, but it's not required.
In the record of Juror 10, as far as is ascertainable from the transcript, and this court can look at Exhibit J from the trial, was most likely one that would have automatically disqualified him because, as was indicated on page 10 of Volume 7 in the transcript, the juror had a record of a grand theft conviction in Florida from 1998, and that is a felony within the 7 years that would have automatically disqualified him from service. And I think it is in everybody's interest that these jurors, a person like that doesn't sit on the jury.
Well, the only way to really be sure that in every jury trial we'll identify people who would be excluded if the information was available is to check in every jury trial.
That would be the fairest way to do it. And
so that would be kind of like an automatic step before every criminal trial.
Before a jury is sworn?
If either party so requests. If either party so requests.
No, she's saying everyone. She wants everyone.
Right.
She wants all thousands and thousands of half-day trials, delays of an hour. Our probation force are declining. I mean, it's not a tenable position from my point of view. And so I'm asking you, what is the best? I mean, you may.
Well, the prosecution could do as it does now and use its authority and discretion to obtain these records and bring them to the immediate attention of the court and the defense, as was done in this case. And there was nothing wrong.
You can't go from the galactic search to only the prosecutor chooses only the jurors it wants to run checks on. That you can't do. There's a middle ground, and we're trying to explore the middle ground. And the middle ground is if either party wants the Corley records before the jury is sworn, the court has to allow the prosecutor to get the Corley records under its authority. If defense counsel wants them, they have to order the Commission of Probation. I understand we can't order the prosecutor to get it, although it may be faster for the defense counsel.
Yes, but I think that might be a problem.
No, there might be a problem.
Yes.
So we get Commission of Probation to do it, and then both parties get it at the same time.
That would be the fairest solution for...
At the present time, if the defendant wants Corey records and the Commonwealth doesn't, at the present time, Is there any way for that? I suppose the defense counsel could ask the court to.
The defense counsel can.
Is
can
that
move
ever
the-
done at present?
Your Honor, I don't know.
I mean, why wouldn't any defense lawyer always, or why wouldn't a defense lawyer always request the Corey records?
Because there may be somebody on the jury with a criminal record, and the Commonwealth nobody asked for the records, and the defendant would be
But
happy.
there's an
to leave
assumption
well
there.
enough
There's an
alone.
assumption there. There's an assumption there that because somebody's got a criminal record, they couldn't be fair and impartial.
Well, that is not true, as was shown in this case, where juror 18 had a minor criminal record in Massachusetts, and she was voir dired and found to be fair and impartial, and she was in fact a deliberating juror. And in this case in particular, nothing happened as a result of this Corey check. The judge had already dismissed juror number 10 because he
You
had...
say, you say nothing happened. Mr. Wood makes the claim, and it is not a frivolous claim, that because the prosecutor selected, based on that prosecutor's view of that jury, the prosecutor selected 4 people. And how many people were on this jury?
18.
18. And the remaining 14 did not have Corey checks. You've got a selection process that applies only to what the prosecutor wanted. And if our rule is, and I don't know if it is, that if either party selects, they should be able to get it, that may be a problem. I have to say, I am somewhat troubled by the fact that the prosecutor and or defense counsel have a right to ask for Corey records. There are thousands of criminal cases. And it's, you know, if we're going to delay, it may be that that's the way it has to be, but if we're going to delay all of these criminal cases, because it's not that easy to quickly get the Corey records. Maybe it is in some cases.
How long does it take?
In my experience, getting a Massachusetts record takes merely seconds.
If you've got somebody who can go and sit at the computer and get them.
Yes, on a computer, I know our investigators can pull them up instantaneously.
It's just
So it's simply a question of identifying a person who's there.
Yeah, you need a name and a social security number or a date of birth, and they can be.
So it's simply, let's assume that it's a one prosecutor case. It's
Well, the prosecutor really should not be the one ordered by the court to
no.
obtain
I understand
these.
that, but the same for the commissioner of probation. I mean, not everybody carries their computer around into the courthouse, so you've got to call the off. I mean, it's, and
Well-
again, there's some cases that are hours long.
I think it would just be a short delay that could be taken into
Can you
account.
clarify something you said earlier? You said in this case, the defendant's attorney did not actually make a request for the records of the other jurors. You said it was more along the lines of musing, wondering.
Yes, that is my understanding of my reading of that.
That's volume
7,
page
168.
168.
That's correct.
If, on the other hand, we interpret that as a request, which was denied by the judge, then what do we do?
Nothing, because there's no indication here that the defendant did not have a fair and impartial jury. And even if after a verdict has been returned, it turns out that there was that a juror was somehow disqualified, that does not that does not have an effect on the verdict. The verdict will stand even if it turns out that there was a disqualification. And a case on that would be Wang Chung 186 Mass 231 or Dele Kiaye 323 Mass 615. And jurors with criminal records sit all the time, as one juror did here, and it does not mean that the defendant did not have a fair and impartial jury, and his conviction should stand under any circumstances. if the court has no further questions on this issue, I would like to quickly address the motion to suppress. In this case, the motion judge correctly denied the defendant's motion to suppress, where the judge's factual findings that the defendant was not arrested at 10:30 a.m. was correct and supported by the evidence, in fact, supported by all the testimony at the suppression hearing, including that of the defendant, who said he was not under, he didn't think he was under arrest.
Did he get a telephone call within an hour of his arrest?
He got a telephone call when he was booked. That was about 4:45 p.m. that day. He was arrested sometime, formally arrested, after the Detective Harris obtained authorization from the district attorney, sometime after 12:55 p.m.
So my question is, did he get a telephone call within an hour after he was arrested?
I think it's impossible to ascertain, but it is not necessary to ascertain that specifically, because there's no indication that there was an intentional withholding of his right to make a telephone call, and he did not make any statements during this time period, and where under those circumstances, well, there is nothing to suppress because no statements were made, and it is not a violation of the right to make a telephone call if the extension of the time period is not intentional and not done in order to obtain some advantage in the investigation. None of that happened here, and therefore the motion to suppress was correctly denied. In addition, the Commonwealth asked this court not to exercise its authority under 33E because these two victims were brutally and cruelly murdered when they were buried alive in a shallow grave on the site of the old Boston State Hospital. Thank you very much, Your Honor.
Thank you, Ms. Saxey.